Good evening, ladies and gentlemen, and welcome to this evening's Bunker Show, here from the Old Bailey Bunker, deep underneath the sewers of the Royal Courts of Justice, where we've got a great show for you this evening. We've got international criminal lawyer Stephen KQC joining us, and we've also got our Bunker Team crew here this evening. So let me introduce to you the lady with the big, lovely, silly grin. Here's Helen.
Good evening, everyone. Really glad to be here and really looking forward to this show. If you want to join us in the chat room, go to darkcityradio.com, come in the chat room. Any questions you've got for our guests or us, type them there and we'll try and get them on the show. The chat room sometimes splits, so make sure you're in the same chat room as Big Silly Grin and Fabrice. Otherwise, go out and come in again.
Thank you, Helen. Also joining us this evening is Jimmy Pearson.
Howdy, guys, and good evening from the Westminster Bunker. I'm so excited about this evening's show. It's awesome we've got Stephen on.
And also joining us is, from No State Project UK, is our legal land regular, Vin James. Good evening, Vin.
Good evening, Fabrice, and evening, everybody. Thanks for inviting me back on again. Great to be here. Looking forward to this tonight.
Lovely to have you on. Without further ado, I'd like to introduce our guest this evening, who's represented some of the most interesting and well-known people around the world, including the current president of Kenya, President Uhuru Kenyatta, and at one time Slobodan Milosevic in The Hague. So, Stephen, thank you very much for joining us this evening.
Pleasure to join you all, and interested to be on your show.
Thank you very much. You've got quite an awesome CV. How did you come to be interested, and how did you come to end up doing what you were doing and representing people in some of the biggest legal arenas in the world?
Well, there's a long story and a short story, but the middle story, I suppose, to give it greater expression, is in about 1993, I went to the American Bar Association conference in New York. I told them I was coming. I asked them, what would you like me to do? And I got a letter back saying, give a paper on international comparative law. That conference was in New York. I thought, as it was the time of the Demjanjuk, Ivan the Terrible extradition to Israel, as well as the discussions about setting up the Yugoslavia War Crimes Tribunal as a result of the Balkan Wars, I thought producing a paper on the War Crimes Act 1989 that the Mrs. Thatcher's government of that time had passed to hold trials of old Nazis would be of great interest. So I turned up to the conference. I went to a room. I gave my talk for an hour on our War Crimes Act, which was of interest to Americans because they have a no retrospectivity as one of their constitutional points and one of their very clearly held legal principles. And that was the end of the matter. And then about 3 years later, I got a telephone call from America again, inviting me to join 6 American criminal trial lawyers who were going to train the first Dutch team to have a man called Dusko Tadic, who was going to be the first Balkan war criminal tried at The Hague. And it was realized that as they were lawyers from a civil code, continental jurisdiction, and that the court that had been set up, the Yugoslavia War Crimes Tribunal, was essentially an Anglo-American model, that those lawyers, very good as they were, in fact, probably the best in Europe at white-collar crime, wouldn't have the forensic skills for an adversarial trial. So we went over to train them in the Peace Palace in The Hague. And after the week's training, there was a knock on my hotel door, and I was asked to go down to the bar, and they'd all had a meeting down there and said, the Dutch feel that they need you to join the team, and we would like you to join their team and do the advocacy in court because, we've liked the way you've done things this week. So I came into it completely by accident and actually from my sort of human rights background, because there was great concern to ensure that any war crimes trials after the Nuremberg Tokyo experiences were in fact fair trials and human rights compliant.
Stephen, was human rights one of the motivating factors behind you actually becoming a barrister, a lawyer?
Actually, I was interested in many things. I was a civil lawyer originally. I did contract work, landlord and tenant employment law, planning law even, and crime was just one of the subjects I did. About 40 years ago, when I first started practice, we had common lawyers, people who dealt with a broad range of subjects and had a wide expertise. The specialization of the lawyers only came about in the mid-80s. And before that, we had a whole tranche of these common lawyers, of which I was one. There weren't any human rights barristers in the late 70s, 80s. It didn't exist as a distinct subject. But there were defenders. There were people who defended in criminal trials, and there were prosecutors. And then there were people who prosecuted and defended. I actually did both, prosecuted and defended. So I can't claim a badge that I'm some big human rights campaigner. I just developed naturally into this area of work. And I understood the principles of human rights that should apply to obtain a fair trial in an international court.
But that right there does, sound like there is a tad of passion for human rights. I've seen you perform, well, not in person, of course, but I've seen some of your performances in The Hague, and there's definitely a distinct hint of personal investment, I would say.
Oh, right. Okay. Sometimes I do get passionate, I think. I was told recently that the more and more the Kenyatta case was going on, I was becoming angry. And I thought, well, that shouldn't be a good trait or a good habit to have. And I'll try and calm myself down as I was so frustrated by the court.
That's interesting. Do you find that an emotional reaction can be really unhelpful in a courtroom?
Yes, emotions are better left out. I mean, if you turn on the emotional tap, it's a bit like someone who cries all the time. You cry wolf too many times. You should only use the emotional tap very, very sparingly, and then get it right. Get it right. The science of advocacy or the art of advocacy really requires you to think about the psychology of these things.
Yeah, and I can very much understand why you maybe have got your hackles up with the Kenyatta case, because it seemed that there was quite a lot of evidence that had been put forward, and it wasn't very clear whether it actually met the burden of proof to be a legitimate case, or whether it had been investigated enough. And do you feel that in those cases where it may not be clear if the evidence is consistent enough, that people really need transparent advocacy in terms of people being able to see how the proceedings are moving forward, so they can have faith in the credence of any judgment? Yeah,
I think that's very true. And I get your point here. At times, the ICC in the Kenyatta case, in fact, most of the time, I felt like Joseph K. Was it in Kafka's trial? Was it J.K.? The initial yes. K, anyway, I remember from reading it 45 years ago. I felt rather like him, a creature, a figure in a landscape, in a legal landscape, wondering what on earth was going on and whether we'd ever get through this whole mess that the court had got itself in. And one of those problems that causes that is the political dimension to these cases. And politics subverts justice. Politics subverts fair trials. Politics should be completely out of having a judicial system. But I'm afraid the ICC is a creature of politics. And it's very, very hard, I think, for the judges to run that kind of show where they're satisfied that there isn't political influences in relation to a case that is being brought or the evidence that is being brought.
Are there any practical shields against political intervention or political influence in such cases?
Do you know, at times I've often thought of Christ going into the temple and throwing out all the money changers and chucking their stuff on the ground. What's concerned me, and this will offend many ears and grate against what people believe because they believe in a campaign against impunity. I do as well. But what they don't understand is that the whole coalescence around the International Criminal Court of the Coalition for the International Criminal Court, which has brought together a whole group of NGOs, all people with very worthy aims for justice, to prevent victims being exploited, to ensure justice being done. But the pressure of the campaigns against impunity that are centered around the court rather than reporting from the court, but whose objectives and commentaries focus upon the court, cause a great deal of pressure. Judges are interviewed by a lot of these NGOs when they go up for appointment to become International Criminal Court judges. That's quite extraordinary.
And do you think that the absence of transparency with those kind of appointments, and I also believe in the International Criminal Court in The Hague, that if a judge who starts sitting a case, if for any reason, for example, ill health, can't continue to sit on the case, another judge can sit in his place, even if he hasn't heard the preceding evidence that the judge who's no longer sitting has heard.
That's right. The parachute judge. We had that in Milosevic. In the third year of the Milosevic trial, 2004, Judge May, the president of the court, was found to be very ill, and he had a brain tumor. And in the recess of the court at the end of the prosecution case, Milosevic also fell ill. And behind the scenes, and unknown to me, there was a rule change, which I suddenly noticed, that if a judge was indisposed, another judge could come in. And before I knew it, that's exactly what happened in the Milosevic case, and a new judge took Judge May's place. There was provision for that, I think, in the Nuremberg Charter as well. But it's a troubling provision, but one can understand it, I suppose, where you've got long cases and you've got judges who, by very nature, probably tend to be older, over 60 maybe. Sure. And then susceptible to illness or poor health. At the ICTY, when that happened, Lord Bonamy, who came in and took May's place, had to read everything and then sign a certificate and declaration that he had familiarized himself with the case.
Okay, so at least that's some degree of accountability that the public can see. You mentioned Nuremberg and the principles laid down there. I'm aware of a few other international tribunals. I know that there was in Malaysia, I believe, a few years ago, an international tribunal which indicted, I think, amongst others, Henry Kissinger, Tony Blair, and George W. Bush. I know that there's Kevin Annett, who's been his International Tribunal for Crimes Against the Church and State. I know there's another organisation, the International Tribunal for Natural Justice, which is raising funds. With international courts and courts and tribunals, I guess, generally, do you feel it's that accountability to the public and that transparency that enables the public to have faith in those organisations or those instruments of justice, that they haven't been politicised and they're as open and as transparent as they can be in justice not just being done but also being seen to be done?
Yeah, I can take us all the way back to that first case at The Hague for the Yugoslavia War Crimes Tribunal, the case of Tadic. And that was a groundbreaking case because it was the first since Nuremberg. It was the first genuinely international criminal trial because it came from the United Nations, the Assembly of States, and therefore wasn't a creature of victorious or allied powers such as the Nuremberg and Tokyo courts. And I remember at the time that all those principles from what went wrong or how people criticized Nuremberg and Tokyo and the feelings of how justice should be done were very much in the air. And one felt that, and one felt that it was being done with a great measure of responsibility. And one of the issues that came up was the recording of the proceedings for TV so that people could watch it all on TV. And I was slightly worried about that, as I thought it would prejudice maybe the defendant's case by people having his character blackened and that being on news in the Balkans every day, and that I wouldn't be able to find dispassionate witnesses. Defense witnesses would be frightened off. And I opposed it. Interestingly, the prosecution also opposed it, but the judges overruled both of us and made it a televised trial, so that the idea being that those people in the former territories of the Yugoslavia could see this case and the other cases and understand what was happening, because there is a territorial disconnect of the theatre of action and the theatre of trial by some 1,000 miles or so. And at the end of the Tadic trial, I had to think that I was wrong and that the judges got that right. So one of the big issues has been the transparency that case Tadic had, which was a good thing. Move on almost 20 years, 18 years later to now, and very little of the trials are seen at the International Criminal Court, because supposedly all witnesses are under threat and all witnesses require protection orders. Very few of those witnesses, unless they are expert witnesses or public figures, actually come and sit on a seat in court, and people see them, hear them, and there is transparency. Virtually every single witness in the case that is ongoing at the ICC on the Ruto case, Kenya 1 case, every single witness has been distorted images heard in closed session because of alleged witness protection issues. Now, that may or may not be right or wrong in that case. I'm not going to comment on that. But my feeling here is that lies that are told, that were told in the Kenyatta case, if there had been a trial, no one in Kenya would have been able to have judged these people. when we did the confirmation of charges hearing, prosecution didn't call a single live witness. They summarised evidence. They produced documents. The only person to call live evidence was me when I called Kenyatta and another MP called Louis Ngie. Kenyatta gave evidence live, and the public saw it and were able to judge him. So that was an interesting development there in relation to transparency of justice, and I think it had a great effect upon his election prospects. He certainly thinks it did.
Yeah, I mean, he's currently is the president of Kenya, and you can see a certain amount of the proceedings on YouTube.
Yeah.
And it's quite exceptional with to actually be able to see with, as you were talking about, anonymous witnesses and the ability to question the veracity of those types of things. The reassuring thing with it being on television is that actually people are able to see the prosecution and the defence for themselves, and that hopefully can only increase the credibility of any tribunal or court.
Yeah, we had in the Kenyatta case, potentially, if we'd have gone to trial, about 20 alleged key prosecution witnesses, but they started dropping out. But that whole group of witnesses were lying through their teeth, and we were able to prove it, which is why the case was withdrawn. There wasn't a case. But the fear was, if it hadn't been withdrawn and the prosecution were forced to withdraw it by the judges themselves, that the public wouldn't have seen how big their lies were. To be frank, the public would have died laughing seeing these guys. A number of them I knew, I'd met. Yeah. They'd asked us for money.
And that's a very interesting point to bring forward and to expose is sometimes when people do exert extortion or leverage. Yeah. And I don't know if you've ever heard of Michael Doherty. He was a guest on our show at the beginning of the month, last month. And he's brought a number of private prosecutions where he's met the standard that's required. And for their own reasons, the Crown prosecution prior to that, sometimes because it's against police officers and employees of the police service that he's filed against, and so I know that also I think the British Constitution Group have been looking to set up some juries to see if there's enough evidence to put forward indictments for those types of prosecutions. In England now, do you think that with the reduction of legal aid, with the tragic hacking of the resources that are there for the Crown Prosecution Service right across the board, do you think that there's potentially a role in the future for the public to empower themselves when they don't feel that the instruments of justice are actually functioning in the way that they'd like them to?
That's a very good point. I'd never thought of it in that way. We used to have a very well-resourced court system for prosecution, defence, judges. The whole thing was like a well-oiled machine. It cannot be said with the same confidence that it works as well now. Anyone who goes to the Crown Courts and sees the number of failings that are made by the Crown Prosecution Service in their delivery of evidence and their conduct of the cases, or troubles the defence have in putting together their case and evidence, and the restriction on their funds they have to present the case. Now, if the state, therefore, is unwilling to apply sufficient resources, I think you do get that tipping point, that thing, that point that you made. Then the upshot of that is that you must permit the individuals or organisations who can resource their own cases to redress the balance. That's a very interesting point you've got there. I hadn't thought of it like that before.
It is. It's a very pertinent point with some of the changes that are coming in now. And I know that I've helped quite a few people who haven't been eligible for legal aid, and I know, Vin, you have as well, haven't you? Helped quite a few people.
Hello. Everyone again, and hello Stephen, thanks so much for coming to do this. We do appreciate it. I've helped people out as a Mackenzie friend with cases in the past, same as Fabrice, and we've found it extremely difficult to try and get just try and see that justice is being done in many of these courts that we've been to. But the question I wanted to ask quickly was that obviously I hope that you're aware that obviously the British government is now talking about scrapping the Human Rights Act, and they want to bring in a Bill of Rights. Yeah. How do you feel that's going to affect us? Do you think that's going to be a good or a bad thing? Because a lot of people are saying that basically this is going to mean that the government is basically going to be in a position where it can't be held accountable to anyone else but itself at the end of the day. So what are your thoughts on it?
Well, I think the Daily Mail and Daily Express campaigns, and by the way, they're selling less newspapers than they ever used to, against human rights has been successful. And to me, it's shocking. I sit as a recorder. That's someone who sits part-time as a judge in court. And I underwent training when we introduced our Human Rights Act. Several courses, in fact, very, very detailed and thorough, to ensure that we understood the principles of this new dynamic that was being brought in to supplement the way we had done things before. And every single tutorial course that I went on, although we said at times amongst ourselves, we were doing that anyway. Actually, there was always an extra part of transparency, for instance, reasoned judgments on everything that you do, giving reasons why you're taking a particular step and how you deal with issues were very important. And one can see from the decisions that came on the criminal side, because the Human Rights Act is not only to do with the criminal side, it's to do with the whole of our justice system. Actually, on the criminal side, provided a number of very good, insightful decisions, which the Lord Chief Justice at that time, Lord Rose, followed by, I think, Lord Wolfe and then Lord Judge, provided great insight into how we should approach and deal with often very complex problems, relying upon that new dynamic of principles we had received from the Human Rights Act. And I thought it freshened up our criminal justice system in that post-Pace area. On the civil side, it's probably even more important. I think many more cases relating to the Human Rights Act come under the civil side, administrative law, asylum law, immigration law, all these areas of laws than the criminal law. And the whole matter over votes for prisoners being some issue that has caused the repeal or attempted repeal, we don't know what the House of Lords will do, attempted repeal of a very good act to ensure that there were more rights put into statutory form rather than leaving it to the poor old judges to define principles as they used to. In my view, that is a retrograde step. It's a political act. It's not an act brought about by any clear philosophy. It's just reacting to decisions that the politicians, government, disagrees with. And I'm very disappointed that David Cameron wasn't big enough to stand up against those backbenchers and against the Daily Mail and argue in a thoughtful and expressive way, in the way that our judges have been doing over the last 13 years since the Act came into being, probably even longer, and making it clear as to why these principles are important. Wholly political act that I think is discreditable.
Yeah, I totally agree on that front, Stephen. And you raised a couple of the cosmetic points that are being proffered by the government to scrap human rights legislation. Okay, the cosmetic public faces of the thing, like such things as prisoners' rights to vote and such, which really don't amount to much. What do you think actually lies behind, the government's ambitions as far as scrapping human rights legislation? What advantage could that possibly give a domestic government?
I think that it's a minority pressure within the Conservative Party. If you talk to Conservatives, I'm not sure they really disagree. I mean, a lot of the judges all the judges I know are pro-Human Rights Act and pro those principles. I haven't heard a single judge agree with the prospect of this Human Rights Act being repealed, which is quite startling, isn't it? I think it's a small minority, and Cameron was so frightened of UKIP and that UKIP voice that he gave into it. And really it was a baser form of compromise, as I called it, discreditable. I think it was short-termism.
Yeah, but that pretty much sums up short-termism. That sums up the nature of politics these days. And, it doesn't really give you much faith in the robust nature of the way that the political beast works. Over the years, in your experience, from when you started to where you're at now, have you seen many changes in the political sort of landscape and the way it's handled human rights and its and the way it views the importance of human rights? We see it on the side when the courts have to deal with it. And one of the key benefits that I have noticed, whereas we used to look at reasonableness, was it Wednesbury reasonable in relation to the discharge of an executive power? Now as well, the extra dimension of proportionality, which comes about from the Human Rights Act, is, I think, a greater safeguard for justice in our society in relation to issues of the use of power. Was this power proportionate? A key phrase that we didn't use in the courts before, but has been the key phrase and the significant development from the Act. Very, very key. In a whole range of matters such as healthcare, schools, discrimination, Human Rights Act actually impacts on those areas probably to a far greater degree than it does criminal law and criminal justice. It's actually on the acts of the health services, education, etc., where it comes into play.
And there's also another thing which is quite strongly enshrined is the right to a fair trial, and part of that, of course, is the right to represent yourself, to be a litigant in person. And I know you come across with Slobodan Milosevic. He was very clear in wanting to be a litigant in person, even with his health issues. And I know there's quite a lot of our listeners who have also had that experience, obviously with the legal aid provision being cut now. To affect quite a lot, even more people than it ever has done. And the principle that I've heard you mention before, that everybody is entitled to equality with justice. What are the challenges that you can have with litigants in person from your perspective, and also the matter of jurisdiction and the element that a court has to actually hear a justiciable controversy. Because, for example, there's a number of travellers. I know we have quite a few of the Druids Against Fracking who follow our show, and these are people who have had no interaction with the state and often ask for the evidence of the authority of a court to sit in judgment over them.
Yeah, it's a good point you make there, because more and more people are having to represent themselves in court now, and judges have all of us been trained to bear that in mind, and that you approach matters differently if you don't have a trained lawyer. Now, there's a difference between the accused, say, who does have legal aid and he's been given a solicitor, a lot of money's been spent, and then someone comes in and tells him, oh, well, X is better. Rarely is, by the way, but then he wants to sack his solicitors, done all the work, and go to X. That's a luxury, when the state's paying for... sorry, my phone's just ringing here.
Okay, it happens. And yeah, it's
still on. Can you hear me?
Yes, we've got you back.
Oh.
Okay, we can hear you fine.
Hello?
Hello, we can hear you fine. Can you hear us?
Can you hear me?
Yes, we can.
Okay, well, we seem to have lost Stephen for a minute. We'll get him back on. And I hopefully talk to him a little bit, because I've had a bit of experience being a litigant in person. And I've got a few questions I'd like to ask him. If anybody wants to jump in the chat and ask Stephen a few questions, hopefully we'll have him back on in a minute.
You can hear me. I can't hear you guys now for some reason. Shall I continue with what I was going to say? And that was that, I hope I'm not talking over anybody, and that was that more and more people are having to represent themselves, and judges are being told to pay particular attention to make sure that the trial is fair. Now, that comes about to an increasing extent from the Human Rights Act, and making sure that a trial is fair. And if someone's not represented by a lawyer and so isn't aware of legal provisions in his favour, the judge must make sure, so that he's had his fair trial, that the side without the lawyer is not disadvantaged. A very, very key principle. I'm afraid I've lost my sound from you.
Has it returned yet?
So maybe you have to send me questions typed.
Okay. Well, we'll type in a few questions for Stephen now. So if anybody else has any to type through. Vin, have you found it interesting with what Stephen's had to say so far?
Yeah, I'm finding it very interesting. It's there's a lot of questions I'd like to ask him, and we've only got an hour, so we haven't got a lot of time. And it'd be great if we could have him on again in the future, and we can obviously pose more questions for him that way. Hello. Oh, Stephen, are you back?
Can you hear us yet, Stephen? No, it doesn't sound like it. What?
Yeah, I was going to say. So it's obviously we've only got about 20 minutes left now. So yeah, there's a lot of questions I'd like to ask, but I think it's mainly the issue, obviously, of the right to a fair hearing that concerns us the most. And I wanted to point out the fallacy that we've identified regarding
the biggest obstacles when you're representing yourself is lack of knowledge of legal provisions, elements of the offence, indeed how to shape evidence so that it deals with the elements required to prove an offence or is a defence to the elements of an offence, simply because you're unaware of what's out there that may be an important provision. For instance, on theft, intention to steal and abandon property, that kind of thing. But it's just not being switched on to how you can best help yourself, because obviously a lawyer has that skill and understands the law better than a layman. Sometimes lay people, I must say, do a very, very good job.
You've done a few of those jobs yourself, haven't you, Ben? What would you say to...
there can be a crime if there's no victim, because those are social controls. And indeed, you can sometimes commit a crime without it taking place. For instance, attempt to murder. I mean, the murder hasn't taken place, but the attempt is sufficient. Genocide, attempting genocide, you don't have to have committed the genocide, and the genocide doesn't need to have taken place. It's merely the attempt.
That's kind of interesting. When you consider the what David Cameron recently said about for as long as we've known, as long as you stay within the bounds of the law, we won't bother you as a government. But that's not good enough now. How did you feel about David Cameron's statement?
I'm sorry, we're having a few technical problems with Steve dropping off a little while. He should be joining the call as we put through the questions. He's just dropped off for a moment, but it was interesting to hear Stephen's thoughts on the Human Rights Act, and I know, Vin, that you found that to be quite an important element when you've gone to court, and you've asked if you're entitled to a fair and meaningful hearing, and if the proceedings are in accordance with the European Convention on Human Rights.
Yeah, that's right, because it's like Stephen says, these are principles that they're meant to stick to, and I'm okay with principles if they're sound and they've got logic to them. And this is the thing with the right, the presumption of innocence and the right to a fair trial in that respect. And and he mentioned the elements that must be proven, and obviously an issue that we often raise is the applicability of the law, proving that an act or a statute actually applies to somebody. And so, but the thing is what we often find is that it's automatically assumed that it does without the prosecution ever actually bringing any evidence forward to show that, and therefore that obviously is in contradiction and in conflict with Article 6, because if you're going to be presumed innocent, you must be presumed innocent of all elements, and none of it can be assumed, and that includes applicability of the law, and this is an issue that we do bring up and raise in court.
Certainly.
If you look at some of the clips of Stephen on YouTube, you can see it kind of reflects some of the stuff where you're coming from with is trying to establish jurisdiction, but on a national level.
Hello, hi.
Hello, Stephen. Thank you. Thank you for coming back to us.
I'm sorry for causing all that problem. We're using modern technology, which is great, so we can all speak. But some of us have problems, obviously.
Thank you very much for joining us. We're in the home straight. We've got about 10 minutes left, and we were just asking about how the obligation was created for citizens to apply to legislation for victimless crimes, and I think Vin also had a point about the jurisdiction of the court and how that's how the prosecution brings forward evidence of that when requested to.
Yeah. These victimless crimes. I mean, they're all about social controls, aren't they? This is how you have to behave. You have a car, you have to behave this way. You jump the traffic light when you're supposed to stop. Evidence from the camera is sufficient rather than a policeman who's seen you do it.
I was going to say, prior to getting to the merits of the camera and the videotape that they may have, in terms of actually how the Road Traffic Act, for example, becomes applicable to a person when that obligation is created. Because often when we ask prosecutors for evidence of that, it's often not forthcoming. For example, we had a gentleman on last week, Gary Capps, who was saying that actually when you're a member of the military, that you agree to abide by the military law. And I guess the same sort of thing with the ecclesiastical church law. And they can obviously show your signing papers with the military. So how's that kind of established in a conventional Crown Court?
Offences under the Army Act and things like that. Well, they have court-martials that deal with that, don't they? They have their own military justice system, and I don't think many of those offences, other than the big offences, in relation to good order and discipline, come actually into the criminal courts. They go into their own court system. So again, they are regulatory matters that how your behaviour and how you can be punished because you've signed up to a particular system. That's a philosophical point that I'm not sure I'm qualified to answer.
I was going to say, I mean, in terms of the layman asking for evidence of that takes it out of the realm of philosophy and into the realm of disclosure of evidence to show an evidentiary chain to show that element of the alleged crime has been established. We've got a question from the chat room.
Oh yeah. Well, just before that, I just wanted to say, when you were saying,
I was going to say, I mean, in terms of the layman asking
that it was a philosophical question
of that takes it out of the realm of philosophy and into the realm of disclosure of evidence.
We meet a lot of people who feel that the government isn't exactly how they'd like things to be run in this country, and think that that some changes are needed. And so when they're being forced to comply to the law of a government that they believe may be corrupt, they're asking the question, how was my obligation created? How, to abide by those laws? So, it's a question that we've asked in a courtroom, and what we were asking for was, some sort of courtroom evidence of how our obligation is created, the factual timeline, and how that exists.
Yeah. This goes back to first that evidence laws on the statute book speak for themselves as having been passed if they are procedurally passed through Parliament and have been signed and are through either as a statutory instrument or a statute itself. And whether that, and if validly signed, and then receive the royal assent, or the minister, in terms of a statutory instrument, signs it, then it comes into force as part of our.
We're running into the last couple of minutes of the show, and I've actually had a question come through in the chat room from Gary Capps, our guest that was on the other week, and he asked, how would one prove that a malum prohibitum is rightly applicable?
That a what? A
malum prohibitum?
A malum? What's a malum prohibitum?
He's in the States, so it may not be a term you're familiar with.
Yeah, from my Latin, a prohibited malice.
A ceremony of
assertion. It's a statutory offence and not.
You say, is ceremony what makes it applicable?
Right. I don't know. I can't answer that.
Questions. Okay, you don't know.
Yeah.
All right. Well, I think we'll start to wrap things up anyway. It's been brilliant to have you on. I'd really like to talk to you some more if you were willing to come on again sometime.
Yeah, maybe we can. I'm just writing stuff on Egypt at the moment, where in fact the people did take the law into their own hands twice, if you remember, and there were a series of revolutions, and that's an interesting balance there, how eventually the will of the people overtook the constitution. Very interesting, the Egyptian situation on that, and I'm having to write reports on it.
Oh, we would so love to have you on to speak about that, and also too some of the stuff we didn't get a chance to talk about, like Guantanamo, and a little bit more about the Hague and the goings on there. So thank you very much for coming on. It's been absolutely brilliant and illuminating.
Pleasure. Thank you for inviting me. Okay, have a good evening, everybody.
Thank you very much indeed, and we really appreciate it, Stephen, and all the best with your work on Egypt. Is there anywhere that people can go to find out more about what you're doing?
If you go to www.figure9bri.com, that's my chamber's website. Where we have stuff posted, and you can search and get a load of back information on all sorts of stuff from Bangladesh, Egypt, Kenya, whatever. Yeah,
brilliant.
Libya. Yeah. Okay.
Thank you very much. I found it very, very interesting and enlightening to talk with you and to have a look at your work. We're just about wrapping things up this evening, so it's good evening from me. We've got Dark City Cannabis Compassion Club coming up next, and after that is the Max Steel Show. So it's good evening from.
Yeah, good night, guys, and thank you. And here's over to Helen. Good night.
Good night, everyone. Thanks for listening. Been a great show. Don't forget to stay tuned for the Compassion Club next.
Okay, thank you ever so much, Finn, for joining us this evening, and hope to see you again soon. And I think actually Vince just dropped off, so thank you very much for joining us this evening. Thank you very much for your input. Thank you ever so much for your